The constitutional right to due process implies a presumption of innocence for criminal defendants. That means defendants don't have to prove their innocence. Rather, the government must prove guilt beyond a reasonable doubt. But does that mean the government has the burden of disproving every possible defense to the charged crime? The Indiana Court of Appeals addressed that question in the case of Geljack v. State. Kenneth Geljack had a suspended license because of his habitual traffic offenses. So when Geljack's daughter needed to go to a doctor's appointment, he sat in the passenger seat while his wife drove. They noticed the brakes starting to go out, but arrived safely at the doctor's office. While Geljack's wife and daughter went inside for the appointment, he decided to drive the car to a nearby mechanic instead of calling a tow truck. On the way, the brakes failed, and Geljack ran a red light. A police officer pulled him over and arrested him. The state of Indiana prosecuted Geljack for driving with a suspended license. The elements of that crime require proof that the defendant was driving a vehicle while having a suspended license and with knowledge of the suspension. Geljack asserted the emergency defense, claiming that he had to drive the car to the mechanic to prevent the failing brakes from endangering his wife and daughter. At the close of evidence, the judge instructed the jury that Indiana's emergency defense statute requires the defendant to prove that driving was necessary to save a life in an extreme emergency. Ultimately, the jury convicted Geljack, and he appealed to the Indiana Court of Appeals, arguing that Indiana's emergency defense statute unconstitutionally places the burden of proof on the defendant instead of the state.